Hey Jen, good to be with you today. And here we go with take 2 of our session for the HubSpot Users Group. Sorry everybody for the tech difficulties earlier today.
Yeah, Sharon's in a new location with better internet. So we're here to record, although not live, for you the video about her presentation about how B2B tech marketers, what they need to know about privacy and consent laws. So it's no longer noon Eastern, but we're still going to do some short introductions here. Sharon will speak shortly, and then instead of a live Q&A like was planned, if you do have any questions, just go ahead and email me and I'll make sure to get them over to Sharon so she can get those answered for you. A little bit about me. My name is Jen. I am the owner of a B2B marketing agency and HubSpot Platinum partner called Kiwi Creative. We do work with clients just in the B2B software and tech industry, so that's the reason I'm so passionate about this audience, this group, this topic. We do present Hug events quarterly. The next one will be in December. But for today, Sharon will be our fearless leader talking about privacy and consent for marketers.
Thanks, Jen. And a huge thanks to Jen for all of her patience and her behind the scenes heroics to get this going. I'm Sharon Toerek. I am the founder and owner of Toerek Law, which is a national firm based in Cleveland, Ohio, that works with independent ad marketing and communications agencies, basically helping them protect their assets and to turn their IP into profit or revenue. We focus on marketing law and intellectual property law for agencies, including compliance areas like data privacy. I've presented at many workshops, seminars, and breakout sessions at some national conferences you might have heard of, like Inbound, and I've been very active in ad industry circles for about the past 15 years. So I'm really excited to be here today, really honored to be asked to present my perspective on data privacy. So I would like to start, let's just take a level setting here for a minute and take a quick look back to where we've been. And I want to give you just a brief refresher on the data privacy regulations and how they've evolved over the last 2 years. Most of us are certainly familiar with GDPR, the General Data Protection Act, but a brief refresher that we have actually been dealing with GDPR for about 2 years, a little longer than 2 years at this point. It was actually enacted in 2018. It is the standard for information privacy for companies and organizations that serve or communicate or sell to residents located in the European Union. The significance of it for those of us who market in the United States and in North America is that it's really been regarded as the gold standard by which all other data privacy regulations and rules have sort of been created. So it's important to pay attention to it for that reason alone. But in addition, there are good reasons, which I'll go into in a second, why you might think GDPR isn't as relevant to you as it actually is in your day-to-day working lives. So a quick refresh on what kind of information does the GDPR actually protect? What is it designed to address? Obviously, personal identifiers like names, addresses, and ID numbers of consumers. Any web data, such as the location of the consumer, cookie data, IP address, RFID tags, biometric data, health and genetic data, racial or ethnic data, and data about things such as sexual orientation and political opinions. There's some misconceptions in the United States amongst marketers about whether or not GDPR is actually relevant to the work that you do on a day-to-day basis if you don't work with brands who sell in the European marketplace. And a common pushback we might hear from the agency folks who we work with is that we don't do business in Europe. We're not targeting consumers over there. And so GDPR is not really a factor for us. And to that, I would say not necessarily. First of all, many brands have within their databases actually collections of data that have come from all different places, perhaps a direct mail campaign, perhaps a trade show, perhaps a contest. And in many cases, those databases do include information about European consumers, and the brand owner of all that data may not even realize it. Next, I'd like to remind everybody that it really doesn't matter what your client's target market is, or where your client is located, or where your agency is located. What matters is where the consumer is located. If there's data of a consumer in a database, and that consumer is a resident of the European Union, then GDPR does apply to that individual. And it also doesn't matter if the consumer ever does business with your client, which may seem a little unfair, but it is the law. What matters is, do you have their data, whether or not you've ever made a sale to them. So keep those things in mind, because as I've indicated, they are sort of woven through the privacy regulations that we see in the United States, currently being enacted on a state-by-state basis. In the United States, where we stand today in September of 2021, is that there's no federal standard yet on data privacy. This is one of those areas where big data, brands, small businesses, agencies, everybody is sort of aligned at this point on their desire to have one set of rules to follow regarding data privacy. What do we have to do? What are we able to do? And versus having to navigate this patchwork of state-by-state privacy regulations, which is where we are today. California, as many of you I'm sure remember, has led the pack in the United States for data privacy regulations with the enactment of CCPA in 2018. And other state leaders in this area have been states like Colorado and Texas. Surprisingly, Texas tends to have a very business-friendly climate. And so it's interesting that they've been one of the leaders in this area in terms of enacting data privacy legislation. None of the deadlines for the statutes that these states have enacted have been tested yet, and most come into effect in 2023. California actually enacted CCPA and then subsequently enacted an even slightly more restrictive regulation called the California Privacy Rights Act, which will be effective in 2023, and which marketers should be thinking about getting ready to prepare for today. Just to refresh, because California's standard in the United States is sort of the gold standard in terms of state data privacy regulations. CCPA requires that we disclose to the consumer what data we're collecting and why we're collecting it, what the business purpose is for asking for it. It includes allowing consumers access to their own information in some sort of portable data format so that they can extract it if they ask. The absolute consumer right to opt out of you sharing of their data and data selling. And the right has to be easy to exercise. Things like online data privacy centers, things like dedicated email addresses, something that is simple and that the consumer will have confidence is going to actually reach the right people, either at your agency or at the brand, in terms of a consumer exercising their wishes regarding data privacy. The privacy policies need to be conspicuously posted, or the link to them at a minimum must be conspicuously posted so they are easy to find. And this right to be forgotten, which is the consumer's right to ask you to delete all the information you have about them in your possession, is a hallmark as well of the CCPA. And you cannot, as a brand, discriminate against a consumer for exercising their rights. What does that mean? It means things like more expensive pricing for the products or the services that you own. It means things like making it harder to do business with you in any other way or fashion as a result of a consumer exercising their right. So all things to keep in mind that are currently, as I said, the gold standard and that are features of the California Act. What about big data so far? We've talked a lot about what the regulators are doing and how is big data behaving in reaction to this. I like to always say that technology companies sort of lead the way on this. Business sort of catches up to technology, and then the law sort of sweeps up behind to make sure that everybody understands the rules of the road, or to clarify any gaps that occur as a result of what technology does or what business does to adapt technology. So big data is getting ready for a post-cookie environment, which is basically sort of the catalyst for having today's session today. And what does that mean for all of you? Well, you as marketers are going to have to plan on moving away from cookies and other third-party data and move to solutions that enable you to use first-party data to accomplish your clients' business goals. Big data is furiously preparing for the methods and the processes by which they'll use technology, their own technology and systems, to be compliant with evolving data privacy standards. Everybody's in transition now. Marketers are worried in the meanwhile about what the next big solution is going to be to replace the cookie. And many of you are expecting big data to actually provide a sort of one-size-fits-all solution or answer the big questions here, so that there will be as many solutions to have to vet yourself as a professional marketer. And I'm not confident at this point that that's actually going to happen. And most experts in the field don't feel that way so far either. So that's a great segue into where we're headed next. New regulations and cookies out the window. A couple predictions for all of you regarding the regulatory and the legal framework ahead. The first of which is that we are going to continue to see this wave of GDPR and CCPA-like activity at the state level until pressure ramps up to the point where the federal government in the United States determines to enact a federal standard on how to protect personal data. Until that time, we're going to see state by state enact their own version and interpretation of data privacy rules. And that will mean for many of you who have clients who do business in multiple states, which is just about everybody, that's going to be a lot of regulations to stay on top of. And as states evolve their regulations, once they get implemented, that will be even more information to have to process and stay on top of. So that's my first prediction. My second prediction, and this is based upon the hundreds of master service agreement negotiations my firm assists with on an annual basis, representing agencies, is that there's going to continue to be this acceleration of attempts to shift liability between parties for complying with data privacy standards. Marketers and brands are going to want agencies to be responsible. Agencies are either going to want the brands to assume their liability, or they're going to want the third-party data processors or technology platforms to assume responsibility. And it ultimately ends up to be a discussion on a deal-by-deal basis, depending upon who has more leverage at the time in the deal. I wish I could put it in another way, but that is really what we're seeing out there. And I don't see that changing for a while, because as the potential liability expands, parties are less and less interested in being responsible for compliance for obvious reasons. Prediction number 3, despite what I just said, there really is not going to be any such thing, in my view, as being 100% risk-free or responsibility-free for data privacy compliance. There is always going to be some degree of risk that anybody involved in the chain of custody of consumer data will be assuming by being involved in a campaign, designing the campaign, launching the campaign. So brands and their partners, which is the agencies that serve them, are going to have to make risk decisions on a campaign by campaign and case by case basis, because there will not really be a one-size-fits-all policy for many of you that is going to enable you to be effective in every single client relationship that you have. So something to keep in mind. You'll continue to receive pressure if you're an agency from your brand partners, your clients, about responsibility. And even if you're successful in negotiating an agreement that is reasonable for everybody in terms of responsibility, you won't ever be 100% risk-free. And I say that not to frighten anybody, but just to get you used to the idea that because technology moves so fast, this is a fluid thing. And we're always being presented with new scenarios wherein data can be accessed and used or misused. And so you have to be limber about it and just understand that it is a risk of being involved in the types of direct response campaigns, social media campaigns, and other types of tactics that involve manipulating into consumer data. There's not going to be any one silver bullet for replacing the cookie, is my prediction with respect to the technology changes ahead. There's going to be a patchwork of solutions and technologies to help brands become less reliant on that third-party data, and then simultaneously helping them be more successful at the collection of first-party data in a compliant way. In my view, there won't be any one-size-helps-all solution from the big tech platforms, as I indicated earlier. I would not rest on an assumption that Google or Apple or Amazon or Facebook or any of the other big data companies are going to make sweeping changes or updates that are going to solve your problems immediately, at least for the next few years. And so marketers sort of sitting back and taking a wait and see approach about how big data, how big tech is going to handle this, are really going to kind of behind the 8 ball in the meanwhile in terms of executing campaigns and dealing with this on a case-by-case basis. So it's going to be really important, since there will be a multitude of tools out there for you to use, for you to understand the compliance features of each tool, and to make sure, if you're an agency, that your client understands them as well. Because many times a client will come to you directly with a tool that they're already using that they want you to adapt to whatever work you're doing with them. Similarly, you might introduce a tool to the relationship that you need to make sure that the client needs to understand how to use. Because the reality of agency client relationships these days is that there's a lot of teamwork involved. There are a lot of thumbs in the pie, if you will, at the end of the day in a campaign before it goes to market. And so everybody really needs to understand everybody's role and all the compliance implications of what they're doing. And cross-training is a great idea in these circumstances too. Consumers are going to continue to act with more and more platforms. And while we could look at this as an opportunity for more things to go sideways, I really choose to see it as an opportunity for more things to go well, or more opportunities to get it right for opted-in data. Every new opportunity to access a consumer who wants to give you their information in exchange for having a relationship with you, no matter what that might mean, an information exchange, an opportunity to have a conversation. Each of these platforms, if used properly, is going to provide you some kernel of an idea about how to do it correctly, how to really engage with the consumer so that they are willingly giving you their first-party information, and that you can form a tighter relationship with them. And there'll be more opportunities to get it wrong too, right? The more platforms there are, the more bugs, the more mistakes that can be made as you implement a campaign using them. But what I think the really good news here is that there has never been a better opportunity for brands to sort of reassess their relationship with their data and with their targeted consumers. It's an opportunity to truly clean your data up and form tighter and more relevant bonds with the people who actually want to hear from you, the customers and clients who actually want to hear from you. And so this is a great time to re-engage your clients into, to interest your clients in re-engagement campaigns with their customers, to making sure that the marketing spend is really being directed towards forming those relationships with the people who are most likely to want to buy from them. So I've told you a lot about where we've been, about where we're going, about a few of my predictions from a regulatory and a technology perspective. What do you do with all of this information? Where do we go next? So let me give you a few tips from my perspective of things that you should put on your short list to do to get ready for a first-party data world. First of all, be super transparent. Be really direct about consumers, about the information that you collect and the specific things you're going to do with it and the reasons why you need it. We're collecting this to send you information about our products. We're collecting this to communicate special deals that we have for people who are friends and family of ours. You get the idea. You're all marketers and I am not, but be clear and be transparent about what data you're collecting, why you're asking for it, and what you're going to do with it once it's in your possession. Also, be selective. Collect all the information you really need. Do you really need a full field of information about a customer or potential customer to form a relationship with them? Maybe you only need their first name and their email address. Do you need their postal address? Do you need their phone numbers? Do you really assess your campaign and the strategy you put together so that you have designed it to be effective using as little consumer specific information as possible? Once you've launched a campaign, it's important, it's critical to be super timely in your response if any consumer reaches out to you to inquire about your personal information. What we like to advise clients to do and what we've helped clients to do is to set up specific privacy centers or privacy request forms on the brand website, so that if a client actually wants to allow their customers to reach out to them, to a specific individual or department, which I recommend, there's a place to do that. A dedicated email address if you don't want to invest in creating special response tools or a customer response center, but have a place where a consumer can easily go to ask about their data. Don't make it hard, don't bury it. Also, have a plan before you launch about what you're going to do or what the client is going to do if you actually receive one of these requests. What is your timeline going to be for responding? What do the rules say about how quickly you need to respond? And do you have the system and the process set up to react quickly, even if it is just a fast acknowledgement of the request once you receive it? So have a plan about how you're going to counsel your client, if you're an agency, to respond to a consumer data privacy request. Be really careful about the company that you keep. The fact that you are here listening to this tells volumes about your diligence in this area. Make sure your clients understand you're being diligent too, and work with third-party data warehouses. If you work with other agencies in a strategic fashion to serve a common client, make sure they understand their obligations, and really be careful about who you select to help you engage in campaign work or any strategy execution on behalf of a client, so that you know that they have high standards in terms of complying with data regulations. And then finally, make sure that when you are engaging some of these third parties, strategic alliance agencies, vendors, that you've addressed data privacy compliance in your contracts with those parties. It's definitely going to be addressed in your service agreements with your clients, especially if, as an agency, you're signing the client's version of a master service agreement, for example. So make sure you have parallel responsibilities built into the third-party contracts that you will all sign with other partners who will help you execute your campaigns. And Jen's going to pipe in and tell you how HubSpot's looking at this and what they can do to help you.
Yes, I'm back on video here. Sharon, I actually came up with a question for you.
Okay.
So let's say you've been listening to this presentation, you're a B2B tech marketer, you get it, you understand the importance of being compliant in all of these areas, but your boss or leadership isn't quite there. They're using those, we don't do business in Europe, we're not headquartered in California sort of concerns. Do you have any, I don't want to say like scary stories, but real life situations maybe from Europe or from California where somebody, a consumer, has come back to a company and they've actually gotten into a little bit of legal hot water because of some of these issues?
Yeah, it's a great question. We don't have too many horror stories yet because most of these regulations, even though we've been talking about them for the past 3 years, have not actually started to tick yet. The implementation of the regulations and the enforcement of them is usually about 2 years behind their enactment, and then COVID happened, which slowed down some enactment. So I don't have any horror stories for you about brands that have been sued for misusing data under any of these new regulations. But what I do have is that what I think is a constructive suggestion for how a more junior marketer within a B2B tech company might respond to that sort of resistance. And that's have your agency help you advocate for why it's important. I'm a huge believer in cross education from brand and agency together. Can think of yourself as educators. It's not your job to be their legal counsel, obviously. That's not the role of your agency or your department if you are in-house at a tech company. But a little education can go a long way, and really helping them understand how to be forward thinking. And if they're B2B tech companies, they by design should tend to be forward thinking. And so for most of them, this isn't new exposure. There's different degrees of comfort with risk though. So I would say focus on education and have your agency help you advocate within your own company about why this is important. And the other thing I would say is that when you as a B2B tech marketer are negotiating your contract with your third-party vendors or your third-party agencies, this is going to come up and you're going to need to be ready to address it. And so your senior leadership within the company is going to have to be primed about how to respond to some of those requests. I hope that helps.
Yeah, it sounds like it hasn't happened yet, but the timeline might be coming soon. So.
Yeah, soon. I think soon, but not yet.
Yeah, if you could actually back up one quick slide here, I'm going to talk a little bit about how HubSpot specifically has addressed GDPR stuff.
Yeah.
They have a great online resource. It's literally called the HubSpot GDPR Playbook. You can go ahead and Google that, or I've hyperlinked this in the slide deck. So it won't work in the video recording, but if you get the slide deck off of SlideShare, you can go ahead and click on that. It will bring you to a very well-written article with lots of practical examples about how HubSpot has some built-in GDPR functionality. And the moral of the story is, if you go to your settings and find it, it literally is one button that you turn on, which enables all of these really cool features. So if you go to the next slide, Sharon, you'll see the disclaimer on the right-hand side that turning the switch on does not automatically make your company GDPR compliant. It gives you a lot of the tools that you need to cover the most common scenarios that you might find as a marketer. So there's things beyond marketing that would go into this, but since we are marketing people here today on the call, turning on that GDPR switch will give you some cool functionality in terms of putting cookie banners on your website. It will give you some of those data, like deletion, requests for information, make that very easy to get to the consumer, like Sharon was talking about. It will put those unsubscribed links even in your sales emails versus just traditionally in the marketing sort of emails. It will give you warnings if you try to re-add people who have been deleted from your system for whatever reason. So there's a lot of really cool features and functionalities in there that I would encourage you to read a little bit about it, turn it on, play around, customize some of those default settings. Just realize though, Sharon's a lawyer. I am not a lawyer. HubSpot is not lawyers, but they're trying to give you as many tools as they can to get you as far as they can here.
Right. It's a great example of them staying ahead of the curve on this from a technology perspective, which, remember, I indicated earlier, they tend to lead in all these areas and in these solutions. And so my expectation will be, I don't speak for HubSpot at all, obviously, but I wouldn't be surprised, let me put it that way, if they're already thinking ahead to how to react to some of the more advanced requirements that the US states are enacting or thinking about enacting. I'm pretty confident that HubSpot's already thinking about how it's going to make its technology adaptable to those things. So yeah, stay tuned. And that's a great feature of the platform.
Yeah, so a lot of people may have heard about the GDPR functionality when it came out a couple of years ago within HubSpot. You might have even turned on the button, but I'm guessing you haven't really taken a second look at it in the last several months or years. So some examples of things you might want to take a second look at, see if maybe you started with a more basic version and now that you're a little more advanced and there's more US regulations coming up that you might want to tailor a little bit more. For example, cookie notices, are they in the language that's native to the person, or are they just in English? Can you decline cookies, just accept? Can you customize what sorts of cookies you want? There's a lot of advanced features you can put into there. Do your forms use pre-checked boxes? Technically, that's a no-no. You're supposed to have people click on the actual check mark to say yes. Is there language on your forms about both consent to storing the data and to then use it and process it and go out and market? Is your privacy policy up to date, or is it something you stole from somebody else's website 5 years ago and you haven't really looked at it? Within email subscriptions, do you have different subscriptions? So instead of somebody just hitting unsubscribe from everything, do you have maybe a different events subscription, from a newsletter subscription, from a vertical or a buyer persona subscription? All those will help people tailor exactly what sort of communications they want to get from you. And then the biggest one is, do you really have consent from everybody in your CRM, or have your salespeople, perhaps throughout the years in the past, purchased some lists, gotten some freebies from trade shows, put people in? As Sharon said, running re-engagement campaigns is great. Making that hard call to either remove or segment out people who haven't been engaged with your communications in the past will help keep you out of that like gray mail. That's not quite bad email, but it's not great email either. So lots of these areas are something that's pretty easy for a marketer to go in and do, take kind of a second audit of your privacy and consent options within HubSpot here.
Right. Yeah, I mean, that's the last point is an excellent one. Our default voice right now is that list purchasing is just way too risky for most brands. I mean, it's a business decision for everybody to make, but purchase lists are a recipe for, unless you want to go through a re-engagement campaign once you get them to get opt-in again, it's risky business for sure.
Well, and plus, since this is a HubSpot user group, it's technically against their terms of services to upload people in bulk who you haven't gotten consent to. Now, there's some gray areas if you're a salesperson and you're really legitimately doing one-on-one communications with a smaller group of people. But yeah, bulk uploading 500, 1,000, 10,000 people to your CRM is a huge risk that will get you flagged for spam, potential privacy issues, as well as if you have too many bounced emails or too many people reporting you, HubSpot will temporarily stop your account until you clean up your list, because they don't want to get blacklisted as a service provider either.
Right, right.
So on the next slide here, Sharon alluded to this fact. HubSpot does know that CCPA is coming. They have an official article on this, which again is hyperlinked if you go to the SlideShare deck. But the article basically says, we're still working on it. So it will encompass a lot of what's already in the GDPR functionality. Because the regulation isn't completely finalized, launched, ready to be enforced, they're still honestly working on it behind the scenes. But like Sharon said, HubSpot tends to lead the pack in these issues. So I'm sure they will have lots of upcoming communications in the next few months about what their software is going to be able to help you do as marketers. Oh, there you go. She clicked on it.
I did. And you can too, once you get the link.
There you go. If you could put the slide deck up real quick, one more. I had just a couple
Absolutely
slides here.
Oh, I think
Oh, you're up there in the tab right next to the CCPA compliance.
Yeah. 1 minute. Getting it.
So while she's pulling that up, the next slide talks about a survey that we're actually doing. We want to survey tech marketers to see what they're currently doing for legal and compliance issues here. So it doesn't matter if you're doing nothing. It doesn't matter if you're doing a ton. We definitely want to hear from you. It's about a 5-minute survey. It's multiple choice. You can remain completely anonymous if you want to. And if you finish the survey, we'll give you a $5 gift card. We're basically putting together a research report. So that will include your data if you would be so kind as to answer the survey.
Oh. And let me share, get us back to our slide. There we go. yeah, I can't wait to see the results of that survey. I'm really excited to know. It's defaulting over to, it really wants to.
You're clicking on the image, which is hyperlinked to go to the next slide.
Got it. Okay. All right.
It's a real good article. You are going to want
It is totally my day for technology to just beat me up. So let me get to it, and we'll show you the contact information on the slides too. But yeah, I'm really excited to see what that survey looks like once you get the results back, because I'm always interested to know what it is that agencies are thinking about and marketers are thinking about.
Yeah, so it's Tuesday, September 14th, 2021 right now. The survey will be open through Monday at the beginning of the business day. So you have just under a week to take it. Again, if you view the deck on SlideShare, this will all be hyperlinked for you. But if you're just watching the video, just go to surveymonkey.com/r/hug-legal for HubSpot User Group Legal Survey. Real quick and easy 5-minute survey will be part of our research report here. So then if you go to the very last slide here, this is usually when we have some Q&A. Unfortunately, we are not live today, so that will not happen. But you can always email me, jen@kiwicreative.net. You can reach out to Sharon on LinkedIn. I'm sure she'd be happy to answer any of your questions. And like I mentioned in the beginning, we do have another hug coming up in December. Mike Richwalski will be talking about high-tech outreach for the next generation of post-pandemic trade shows. That's a long title, but basically what it means is trade shows are probably coming back in 2022, but we don't want to be old school, lots of traffic at the booth, touching things. So how can we have some high-tech outreach before, during, and after trade shows? Lots of really good, cool tech tips will be coming up there in December. So with that, I will say thank you very much to Sharon for hopping on later in the afternoon here. Looks like we got our technical difficulties all sorted out. Again, you've already seen the video if you're on here. We have the deck on SlideShare. Remember to answer our survey, and hopefully we'll see you in December for our next B2B Tech Hug. Thanks, everybody.
Thanks, everyone.